I want to begin my discussion this afternoon with thanking both Senator McGuire and Senator Mitchell. I see Senator Bell has left, but for your leadership on this issue. Not only leadership, but authorship of legislation and helping to push that legislation through, which has really moved us in the right direction of ending the inappropriate use of psychotropic medications. We still have a ways to go, and as the senators know, there are 3 bills sitting on the governor's desk, which we hope after today's hearing, he will see the urgency of signing those pieces of legislation. This afternoon, I want to highlight 2 of the auditor's most critical findings and make some specific recommendations around them. First, however, I want to provide some brief context for the findings and recommendations of the auditor. We have both a moral and a legal obligation to the children we take away from their parents. It is not enough to say that we have removed a child from an abusive or neglectful environment. We have an obligation not only to keep them safe, but to help them thrive, to meet their most basic needs, and that includes promoting both their physical and mental health needs. Our legal obligations to provide health care to poor children in California, including those children and adolescents in foster care, arise under the federal-state partnership of Medicaid, or as we call it, Medi-Cal. Under EPSDT, children must be provided with services to correct or ameliorate physical and mental illnesses and conditions. If there was any doubt about the breadth of this legal obligation to children, it has been set to rest by our courts. The obligation to provide health care under the federal statutes encompasses a clear duty to provide care that meets all a child's mental health needs. But our legal obligations to children in foster care are more fundamental. They arise out of constitutional obligations to those children. Those constitutional obligations include both the duty to meet the mental and physical health needs of children and with respect to administering psychotropic medications to ensure that the procedures for authorizing such medications satisfy the requirements of due process. These constitutional duties to children in foster care exist irrespective of and in addition to our legal obligations under the federal Medicaid statute. If we fail to provide treatment for a foster child's broken arm or their asthma or pneumonia, we violate that child's constitutional rights. Likewise, we cannot be indifferent to and fail to meet our foster children's need for mental health care. More than 20 years ago, U.S. District Judge Henderson observed, "It cannot be questioned that deliberate indifference to a serious mental illness can precipitate as much, if not sometimes more, suffering and distress than indifference to a serious complaint of a solely physical nature. The requirements for mental health care are the same as though for his physical health care needs." He wrote that in an opinion about the health care rights of felons and prisoners. Certainly, our foster children are entitled to at least, if not more, considerate care than we provide to our prisoners. With that perspective in mind, I want to talk about 2 particular findings and concerns of the auditor, one of which has already been discussed here at length, and one of which Senator Mitchell alluded to a bit when she was talking to Director Kent. First, the auditor concluded that a significant number of children administered psychotropic medications do not receive psychosocial services. And second, and perhaps in my mind, the more critical piece, that is a key check and balance for ensuring the appropriate use of psychotropic medications, the so-called TAR, or prior authorization, for off-label uses of drugs administered by the Department of Health Care Services, is not being followed and has not been followed for years. This allows the inappropriate and potentially dangerous off-label uses of psychotropic medications to go unchecked. Okay. As far as recommendations around psychosocial services, I want to make several. First of all, we need to adopt a common definition of psychosocial services. We also need to determine whether the service that we're providing is appropriate and effective. We saw last week with the issuance, I think, of the performance outcome system reports around children in foster care. We now count, the numbers of services provided, the average minutes per beneficiary. We break it down into some categories, but we know very little actually about the quality and effectiveness of the mental health services we are providing. Perhaps the legislature ought to take up the same kind of incentives that the Congress is now considering in the Family First Preventive Services Act, where in Section 111 of the bill, it requires that mental health services must fall into one of three categories: promising, supported, or well-supported practices. And then finally, in this area of psychosocial services, I suggest that we adopt and employ multiple methods of assessing services, both qualitatively and quantitatively. There are limits to what the administrative data can show us, and I think that was demonstrated by the auditor's report and the wisdom of looking at case files themselves to augment what the administrative data shows. And then finally, with regard to the off-label psychotropic medication use, as the auditor pointed out, I believe more than 75% of psychotropic prescribing for children and adolescents is off-label, that it has no FDA approval for the use for which it is being used. California has required treatment authorization requests for any off-label use for years, but the auditor found, for example, of 45 children to whom prescriptions prescribed at least one psychotropic medication off-label, a TAR was submitted for only one. Under California current Medi-Cal policy, an off-label use of a prescription drug may be approved if it represents, quote, a reasonable and current prescribing practice. This standard of review ignores Medicaid's restrictions on an off-label use. And what we recommend is that California dispense with the reasonable and current prescribing standard and adopt the Medicaid law and the Medicaid regulations requirement that off-label use must either be for an FDA-approved use, or it must be listed in one of the three drug compendium. That is what the federal Medicaid law requires. California should move away from its lax standard of so-called reasonable and current prescribing practice, and therefore lead to the more appropriate use of these medications for children in foster care. Thank you.
Thank you so much. Hey, great job.